Who actually owns the content you post on social media? Today on #Lawyer, we have Scott Harper here to explain copyright, trademark, and patent law to all of our listeners. Welcome back, guys. Thank you for being here listening with Andrea and I today on #Lawyer. We're really excited. We've got Scott Harper here in studio today.
Thanks for having me.
Scott's a good buddy of mine. We've been friends for about 7 years now, worked on a case together, and it's crazy that it was 7 years ago that we met because I didn't even realize I've been practicing law that long. But Scott's kind of, in my opinion, the expert on everything that has to do with copyright, trademark, patent law, and a lot of people group that into one specific group, and honestly, a lot of lawyers do too. Scott is one of the managing partners at Harper Bates and Champion,
Right.
A firm that he helped start 5 years ago. And Scott, it's a lot of fun to be around, so I'm glad to have you here on the show today, man.
Well, thanks for having me on the show. Appreciate it, Austin. Thank you, Andrea.
Yeah, absolutely, man. So let's just start off with something that'd be helpful for everybody. What is the difference between trademark, copyright, patent law? What's the differences between all of those things? Why are they not really one specific area of the law?
It's a great question, Austin, and it really breaks down to people hear the term intellectual property law.
Okay.
And that really is broken down into patents, trademarks, copyrights, and trade secrets. Sometimes we forget about trade secrets. Right. But each of those are codified under the federal law, and they protect different things. We hear a lot of people say, I want to patent that trademark or copyright my patent. And that's really not, they're different things, but they protect different facets of things. So like, for instance, patents protect invention. So they protect things that people create to solve a problem.
Okay.
Mm-hmm. Trademark, that's your brand. It's whenever you put a mark on a product or a service and put that out there to the public to consume. That protects that goodwill so that people know when you're buying that brand X, that's the one you want. Copyright protects creative, artistic creations. So think movies, films, songs, things like that. That's what a copyright really protects.
Okay. And I think a lot of people, the one I hear the most, I think is I want to patent this idea. And there's a difference between things that you can actually put a patent on and things that are just kind of a combination of different processes, right?
That's exactly right. Like, first of all, leading with that patenting an idea, I hear that all the time.
Yeah.
You really don't patent an idea. You patent the solution to the problem that idea stemmed from.
Okay.
But it's great. But people, they'll think about how can I solve something or fix something and how can I do it better? And that's when you go down that patent road.
Okay. And from my experience, a lot of people say that, at our firm, we handle trademark, copyright, patent, trade secret law. Mm-hmm. But really, from my perspective as a lawyer, you need someone like you that's really skilled in this position because it is pretty nuanced, right?
Yes, Austin, I'm glad to hear you say that. That's job
you,
security.
Yeah.
That's right. But yes, and with respect to patents too, you have to take a second bar exam. So you have to take a registration exam to be licensed to prosecute patents to the trademark office.
And I think that's something a lot of people don't actually realize. Mm-hmm. And so, do you think it's fair to say if you have, Joe Schmo down at Schmo and Smith saying, yeah, absolutely, I can, help you with this patent situation, no problem. Should you kind of look up and see if he is licensed in the patent bar?
I think you should.
And if he's not, should you run very far away?
You should run very far away and don't spend any money.
No money, none.
Exactly. It's not an inexpensive process for sure, but it's like, we all know you get what you pay for.
Absolutely.
So be careful when you're selecting that practitioner.
Yeah. Mm-hmm. Well, and as a rule, kind of for our audience, who are the types of people that, in your opinion, typically should be using trademark and copyright lawyers? What types of industries?
Well, it depends on what you're doing. But if you're a person who wants to develop a brand, you have a product or a service, and you're trying to get out there in the marketplace, certainly you want to pursue a trademark. Look into trademark and getting a registration for your trademark. If you've invented something, a new process or piece of machinery or equipment that does something, then you're going to go down that patent road, and you need to look for a patent lawyer and try to get a patent on that, because those pieces of property give you exclusive, valuable rights. Mm-hmm. Patent gives you the exclusive right to make, sell, or use that product, or to keep others from doing it. You don't have to make it, but you can keep others from doing it for a limited term, for the 20-year term.
Right.
Trademark's the same way. That's your brand identity. That's how people associate that product with you, and they build up that goodwill with it. So it's very important for people who are either inventing things or putting products in the market to get those kinds of protections.
Yeah, and I think one of the great things that I loved about bringing you on the show is that you've got a vast array of experience dealing with Fortune 500 companies all the way down to startups. And
That's
so
right. That's right.
There's a lot of different things that we can talk about today, and I know a lot of things we've talked about are the misconceptions that are associated with this, all four of these areas of the law.
So, in your experience, in your practice, what are some of the most common misconceptions that you've come across and that you've seen?
In terms of what patents and trademarks do, or what we can provide for people?
I think in terms of what patents and trademarks can do, like maybe the top 3 misconceptions that you've run across.
I think first of all, some people will think, obtaining a patent or trademark is not, quote, worth the money or worth the time. They just want to rush to market and get their product out there. But what they're not counting on is the amount of information, especially on the internet, where people see your product, knock it off, and they've beaten you economically in the market. Whereas if you obtain a patent or obtain a trademark, that helps give you protections that you can use the legal process to force them to stop doing what they're doing and infringing your goods. So that's one misconception. I think another one too is that the process is easy and that you can do it yourself
DIY,
online.
there you go.
DIY.
Yes.
We are big believers in not DIYing your own legal solutions, from divorces to apparently patents now.
And I think we've all seen that in our industry. It's like me trying to do surgery on myself.
Oh, gosh.
Yeah, I've got a razor knife, but it's probably not a good idea, to do that. And so it's the same with lawyers. I mean, it's legal. Legal is a very important part of any product development, product launch, and people should take that seriously and get good counsel whenever they start that process.
And then the third misconception that you've really run across.
The third misconception is that I would say folks think that once they obtain a patent or a trademark, that protects them from any and all comers. There are nuances with these. With patents, you have your claims, and that's like the deed to the property. And so if someone isn't stepping on your property, but they're close, they may be able to compete with you in the patent arena. Same with trademarks. Just because you trademark a particular term does not mean you own that everywhere for the rest of your life. Trademarks have terms. Trademarks have geographical limitations as well.
Geographical limitations. I think that's something that not a lot of people realize, including lawyers.
Right. That's exactly right. If you have a registration, you're limited to that country's registration or that state's registration. The individual 50 states have state trademark registrations you can obtain. If you don't have a registration, then your rights will be constrained to where you've sold or used that product or service. So you could be limited to say Dallas. You could be limited to the North Dallas area, North Texas area.
It's pretty darn limited.
That's right. That's right.
Also one of the things that I learned actually working with you, 7 years ago was that once you get the trademark, and I believe it was trademark, you obviously correct me if I'm wrong, but you have to actually police that and make sure that you're going out and protecting someone else that's trying to use that brand, or you could also potentially lose some rights to it.
That's exactly right, Austin. We obtain trademark registrations for people, and then when they get that registration, they say, okay, everyone will stay off the lawn. And that's not true. It's incumbent upon the intellectual property owner, whether it's a patent, trademark, or copyright, that you have to police it, send the cease and desist letters, and if need be, take those folks to court to make them stop infringing your IP.
Yeah.
And that's kind of the second lift. There's the expense of obtaining that protection, and now you have to go out and police it yourself.
Yeah, and I think our users need to understand that part because, again, like Andrea said, we as lawyers who don't practice in this area learn stuff about this, from talking to people like you, and having a lawyer that understands, hey, this isn't a one-step process. This is a one, plus we have to be vigilant in pursuing and protecting our patent, copyright, trademark. That's really important because that's something that you don't hear about a lot.
Yeah, and so I think, pivoting off that question, let's go ahead and give a hypothetical, right? So say I create a shoe line. What woman doesn't love shoes? And I describe it as the purple footwear line, and I have a signature shade of purple that I put on the bottom of all my shoes. What are the steps that I need to do to go ahead and protect that? Because that is part of my signature and my brand. What am I going to do to protect it, and what am I going to do to police it down the line?
Well, there are a few things that you should do before you release it, especially in the world of patents. Under the patent law, if you publicly disclose your invention in the United States before you have filed a patent application, you have 1 year from the date of that first disclosure file a U.S. application, or you are forever barred from filing, which
You mean
means
I
you've
can-
dedicated it to the public.
I can lose my purple
You're exactly right.
shoes.
That's exactly
That's a problem.
right.
'Cause I mean, I like purple.
If you're pursuing, but that's if you're pursuing patents. Now,
Podcast likes
Yep.
purple. You see
Quite
that around?
literally.
that's exactly
My
right.
jacket is purple.
And so, but there are different aspects of that shoe that you could protect with, say, a U.S. design patent.
Sure.
There may be aspects that you could protect with a copyright, or some under a trade. We call it a trade dress registration.
A trade dress
Yes.
registration.
And that kind of is a catch-all for things that don't fall within the requirements for a design patent or copyright protection. But some of those different avenues are how you would need to look at it. So you would need to go to a great IP lawyer,
Someone
that
like
you know,
yourself.
and you would need to sit down with your product, and we would go through those steps and say, what types of protection could we get here? Because the types of IP we talked about earlier, Austin, aren't mutually exclusive. You
Okay.
can get a utility patent and a design patent on the same article.
Fascinating.
You can also maybe get copyright protection on that article. It just depends on what features you're protecting. A design patent protects ornamentality, style. A utility patent protects function and methods and processes.
Interesting. So say I create, gold chain link necklaces are very in for spring and for summer. So say I'm able to create.
You knew that, right, Scott? That gold chain
I'm
necklaces
learning
were for
fast.
spring and
I'm
summer.
learning fast.
That's good.
So say that I create, I'm no jeweler, so I'm going to make this up. This a special type of gold plated necklace where you can swim, shower, and for some magical reason, it actually doesn't tarnish and wear off, which is very typical with gold plated jewelry because it's just gold on top, it wears off. And by doing this, I'm going to be lowering massively the price point for these like chunky gold looking necklaces that are just on top of brass or of brass. So if I'm able to, do that, then how would these different, protections go into protecting how I've created this particular type of special metal in the necklace? And also protecting the design because, I want my design and my art to be protected too, but also the utility of what I've created.
Well, you've said the magic words. You could possibly pursue a utility patent, Andre,
Okay.
on the process for treating that metal so that it has those desired effects and advantages. On the design side, possibly you could protect the ornamental features of the necklace with a design patent. Then there's also possibly copyright protection that could fall in there as well. And then when you name it, because we got to come up with a name, right? So
Let's call it the Elena.
the Elena. So you'd look at, can we obtain a trademark for it and get a trademark registration for it?
Well, and I think that all this discussion, the best part that I keep thinking about is these are all things you need to be doing, from what I understand, at the beginning of the process of you creating this new idea and this new product, right?
Austin, you're exactly right. When entrepreneurs and startups get their capital together, one of the expenses is legal, and many of them defer that because they want to put it into manufacturing
Sure.
or marketing or getting the word out. And I totally understand that. But like we've talked about, there are some things you can do that when you launch it, it's going to put some time constraints on you to obtain certain protections. And so, for instance, in the trademark arena, it's always a good idea to do a trademark search to find out if someone else already has that mark and has already registered it and is using it on the same good or service you are. So if there's an Elena and they're using it to sell batteries and you're going to be using it to sell jewelry, probably not a problem. There won't be an issue. But if there's someone out there that already has an Elena line in jewelry, then you may get a letter from their lawyer if you launch using that mark saying, hey, we have a trademark registration here and you're going to need to stop.
And there's, at the end of the day, what are your options if you receive that letter?
That's exactly right. Well, the options typically are stop and pay us money, or we're going to be filing a lawsuit against you for a lot of money to make you stop. So the options generally center around stopping and rebranding or taking a license, possibly, if it's a
Interesting.
patent situation. So there are some different outcomes, but it really depends on what that IP property holder wants out of the deal.
So very case-by-case basis.
Yes, very fact specific.
Well, and one thing I'd like to ask just before we move on is when dealing with startup companies and entrepreneurs, a lot of them, like you said, like to defer legal costs, and it's because this process can be expensive. And what advice would you give to someone who's a founder or a startup entrepreneur that probably has some ideas that need some of this protection, but is concerned about how expensive it can be?
I would tell them, first of all, they're going to go to the internet and Google patent lawyers.
Right.
And they're going to get a list of patent lawyers that's going to come up. And some of them will be great, some of them will be good, some of them will be the ones you want to run away from. So, I think a lot of the good advice is to vet, to look at legal. You're going to have to do it. It's you either do it up front or on the backside when you're getting charged with infringement or something like that. It's already out there.
It's going to come up one way or another.
But make a budget and then reach out to your colleagues and look for referral. Look for good help. It's kind of like going to the Yellow Pages too back in the day, but with Google. It's like,
I was about to say Yellow Pages. I'm not sure some of our listeners understand that.
You run the risk by doing that. So look for someone, and typically most people have had a run-in with lawyers that can say they're good folks, or we can refer you.
Right. Well, I know one misconception that Andrea and I talked about a little bit before the show got started is this term that everybody, especially on the internet, loves to throw around these days, which is that they're not infringing on someone's trademark or I guess, probably just trademark because of this idea of fair use. And can you kind of break that down for our listeners in ways that are we can all understand?
Right. Well, in the context of like social media, there's Facebook, there's Instagram, and people love to take pictures and snap them and throw them up there. And so they also like to go to those sites or go to Google Images and say, hey, that's a cool picture of a polar bear. I'm going to put that on my website. It's really cool. And what a lot of people don't realize is that even though they're on the internet and can be downloaded, it doesn't mean you're free to use it as you wish. Because under the U.S. copyright law, a copyright interest attaches at the moment that creative work is created. So when you write a song, or you take a picture, or you paint a picture, there's a copyright interest that gets involved. And so that is really one of the biggest misconceptions, is the ease with which people can take images or songs and use them on their own websites for their own purposes. But you talked about fair use, and that's what people will say is, well, hey, I'm not using everything. The fair use is a defense to a charge of infringement. So it's an analysis of different factors. And like I say, it's a defense. So it's not really a get out of jail card free, but it's usually the best defense.
Yeah. Well, and I think you had mentioned to me at one point that part of it had to do with whether or not one potential part of it is whether or not you're using this image, work, whatever, to make money.
That's right.
Right. And people are like, well, I'm just putting it on my website. Well, what's your website doing? Well, we're selling clothes. Gotcha. I mean, that's not fair use, right? So that exception goes out the window.
That's exactly right. Yeah. It is. The fair use defense encompasses, they'll look, are you using it in a commercial manner? If that box gets ticked, then that's one strike. They'll look at the nature of the use. They'll look at how much you used. So in the context of like a book or a song, did you copy 10 seconds of it, or did you copy all 3 minutes and 50 seconds of the song? They'll also look at what you're using it for. They look for if it's a news, if it's a newsworthy item, or it's research, or it's for educational purposes, indicating all nonprofit purposes. Then those boxes will tick that it's a fair use. But you go through this analysis, and at the end of the day, and it's very subjective, a court would determine whether or not what you did was a fair use, and therefore getting you off the hook for infringement.
Well, and so you mentioned it earlier. How does this play into social media is one of the big topics we wanted to cover today. We said it in the intro. Someone takes a picture, posts it on Facebook. Kind of walk us through who owns that? How does that work? What's the situation with Facebook and Instagram, for example?
Yep, that's a great question. And the situation really is, it's in those terms of service that no one reads. But when you sign an account, you create an account with Instagram or Facebook, there are boxes you're checking that say, I agree to all these terms. And in those terms, there will be how they're going to treat the content you post. So in return for posting the content, you're typically granting them a license. I know, like with regard to Instagram, they say you own your content. So you own that picture of your cat or dog that you've put up there. But they say you're granting us a non-exclusive, perpetual, forever license to use it, distribute it, rebroadcast it, and to make derivative works of it, meaning they can modify it.
Oh, wow.
Now, that's something I think a lot of people don't know.
Change the colors, do that kind of stuff. Okay. And there's nothing you can do about it.
And so now, does that license specifically on Instagram, right? Because Instagram these days is used as a launch pad for so many influencers and so many artists and so many young aspiring engineers or people that are coming up with technical solutions or fitness influencers. It's such a wide range. So say you have someone who is an aspiring graphic designer artist, and they put a graphic design for their own brand on Instagram. Now, if I'm understanding you correctly, Instagram can then say, hey, we really like this brand image that you created for your brand, but we can create and modify and change the colors and this and that for our use. Possibly,
yes. Yes, and I say possibly because it is very fact-driven.
Of course.
But whatever they're taking, if it's your photo, if it's your trademark. Now, when you get into trademarks versus copyrights, it can change a little bit.
Sure.
But to generally answer the question, yes, you have given them the right through that license to modify anything you post or use anything you post for their purposes.
Okay, now let's, pivot and change that example a little bit. Say, I'm a fashion influencer, right? I mean, I can dream, but...
What about Scott and I? We can dream too, right?
You can. I'm not trying to be sexist here. You can be fashion influencers if you want.
I think Austin's got a leg up on me.
So say I go ahead and I am developing this fashion influencer brand on Instagram, and I post a picture of myself in a swingy white dress and really big hat. Now, Instagram then could probably, if I understand you correctly, take and modify my picture and use that.
They could.
But now the big question is, can the brand of, say my hat that I'm wearing is Gigi Pip. Can Gigi Pip take my Instagram picture and use it for their own marketing purposes without asking me?
Probably not. And I say that is because the license that you have given to the rights in that picture are limited to Instagram.
Okay.
So you haven't given it to Gigi Pip, et cetera, to be able to use. So there are limitations there. But, it's that fine print, and that's what everyone should read before they do these things.
Well, why would we do that? We're ready to get the account started.
I know, right?
Exactly.
One of the examples Andrea talked to me about kind of when we were getting ready for this show that I thought was really interesting is when you think about a fitness influencer. So we've got a lot of Instagram users out there that are coming up, especially now during the quarantine with home workouts and different processes and things that they're advocating that, hey, I came up with this routine. Yep. This is going to work to help burn fat, all these kind of things. And they're posting these videos on Instagram. Are there any protections or limits that you can see? I know this is a gray area, but just in your opinion, what kind of issues do you see with that situation?
Well, so by posting on Instagram, they're giving that license for Instagram to post it and for the world to view it.
Right.
And so if there are any IP protections they have in place, if someone does start misusing the image or reposting it outside of the Instagram deal, that person may potentially have rights to send a cease and desist letter or tell the third parties to stop.
Yeah.
But that's the difficulty of it, Austin, because like with certain routines and workout routines, you look at reproduction of just the routine, someone in their home using it, that's more of a personal use. You're not looking at a real issue there. But if someone takes that clip and reposts it on their own website and says, this is my routine, and they use that exact clip, there's a copyright issue there for that third-party effect.
And does that copyright issue exist even if, say, Jane Doe, she's gone ahead and created these, unique fitness moves, she's posted these videos, but she doesn't have any actual formal patent protection, trademark, nothing. She's just developing them and posting them because she doesn't know to seek IP help. And then say, Sally Smith, who also is an aspiring fitness influencer, takes bits and pieces of Jane's Doe routine, puts into hers, and then is posting on her Instagram. I mean, what is going to happen at this point? Is Jane Doe out of luck?
You have to give that lawyer answer of possible. There's a lot of facts here. But if the routine is not protectable, let's just say it's not protectable, then Jane Doe would be out of luck because someone, it's like making a chocolate cake. They're take the recipe out of it, but just the act of making the chocolate cake, that's not protected. Anyone can do that. So
and so to pivot that a little bit, say that you have an influencer who has created very unique off-brand Pilates movements, right? And she actually has gone and patented those movements, and then she puts them on Instagram, and someone else is now copying some of those movements and using them in their own routines. How does that situation change?
If they are patented, if you take it at face value that can be patented, then she would still have her patent rights in those movements. And outside of the Instagram environment, if third parties start infringing those patented movements, she would have her patent rights to enforce against them.
So that would be the situation you talked about earlier, where she would need to go out and police her rights and make sure that they're sending these cease and desist letters from their IP lawyer.
Exactly. Because kind of in summary, whenever you post something on a social media, Instagram, you're telling Instagram, I'm going to let you do these things so I can get this out there. But that does not extend to third-party viewers. Those rights do not flow to them. They stop with Instagram. According to their current terms of service, which we have to point to, because those get changed from time to time.
Right, and we get those updates all the time.
That's right.
Yes.
And there's some other stuff that we had talked about, kind of in some real world examples that have to do with these same types of things. And Andrea would know more about this than me, but we talked about wedding videos and music.
Absolutely.
And that was an interesting topic that you were bringing up kind of before we got on the air today.
Absolutely. So, it came to my attention. I recently got married October of last year.
Congratulations.
Thank you so much. And so one of the things that was brought to my attention was that our videographer, he shot this beautiful content. It was absolutely stunning. And it was really important to me that the private last dance that my husband and I danced to, Iris by the Goo Goo Dolls, was incorporated into the wedding video. And, he says, well, Andrea, I can do that for you, but are you going to share this video? I'm like, well, of course I'm going to share this video. I'm a millennial in the 21st century. I'm going to blast it on Instagram, Facebook, whatever. And he's like, you know what, you can do that, but I'm just going to let you know, you might be getting a letter from the lawyer who represents Goo Goo Dolls because you're using that entire song in your video and there may be some IP issues there. He's not a lawyer. I'm the lawyer. And I was like, oh my gosh, why didn't I think of that? That's a little embarrassing for me, but let's talk about that.
He's a smart videographer. A lot of artists are and it's great because I think the exposure to IP has really made a lot of creative types understand that they've got some rights here and they need to be smart about how they give people permission to use them. But he was exactly right. Taking a song, which is, since it's Goo Goo Dolls, it's going to be copyrighted by probably one of the big record labels.
Yes.
If you use that song without permission or without paying their license fee, then yes. If you put that in a video and you post that and blast it everywhere, that is copyright infringement.
Even though I'm not making money off of it, this is my personal enjoyment. I want to share with, all hundreds of my friends on Instagram.
That's exactly right. Because, we would try to argue fair use, but and we would look at all those factors. But that is true because years ago, there was a great example of this. There was on YouTube, a mother posted a video of her young baby dancing. And in the background, it was Prince's Let's Go Crazy song. Universal Music Group sued her. She posted it on YouTube.
Oh my gosh.
Universal Music Group sued her. And it went viral after that.
Oh, wow.
And I haven't followed the case recently, but at last check, I think they were trying to settle it. But it's bounced up and down between appellate courts and things. So in that context, it was just her baby dancing at home. And she was like, isn't this cute?
Wow. And she didn't even pay a wedding videographer to do it.
She did not. She did not.
Well, and Scott, I got to ask you, being an IP lawyer, we talk a lot on this show about what's fair and what the law says, and that's where we kind of get to share our opinions. What do you think about that? Obviously, you practice in this area. Do you think that's something that we as a society should be a fan of as far as protect? Is that too far, or what do you think?
Well, since I represent artists, but I've also represented people on the other side of that equation, I really don't have a position on it other than that it's the law. And if you don't like the law, then vote and change it. And that's it, because those laws were set up to protect artists. And, there's a lot of artists out there that struggle and that put their heart and soul into creating these works. And for someone to just be able to walk up and maybe even not be commercializing it, but to walk up, take it, copy it, and blast it out without their permission, without maybe their desire to do so, that's what the law was intended to protect. But you're right, there are some situations, and it's the hope that the fair use defense comes into play there and applies there.
Yeah. Well, that makes a lot of sense to me that you frame it that way, because you also want to be in control of how your brand is being perceived.
Exactly.
Right? So even if someone's blasting it out in a way that's not necessarily making money, I know we have a brand here that we want to we want to make sure it's perceived a certain way, it's portrayed, it's pushed out there and promoted a certain way. So that makes sense. I get that. So maybe I'm not as sympathetic as I was towards the mom and her dancing baby.
Well, you see it from where you stand. Yeah, that's what they say.
Absolutely.
Very true.
But when you're working on either side of the law, there are those. It's all subjective. It really comes down to a lot of subjective, determination of how it's being done, what the infringement is.
And to pivot off of mom and dancing baby, right? So, access to video and publishing video is very, very egalitarian these days. I don't know if we all, most of us have Instagram accounts. Can you tell it's my favorite social media platform?
I can.
Yes. And so if I am at the office and I see, I don't know, something cool in the trees and I take a video, but then I also have the function of adding, say, a Taylor Swift overlay, and I'm publishing 20 seconds of her music along with my Instagram video to my stories, and am I going to be getting in trouble there?
Possibly.
Are there any exceptions where I can use her music?
It would totally be fair use, or unless you have permission. If you've reached out, and there are some licensing organizations like ASCAP and BMI where you can go and obtain a license for a one-time use or multiple time use. But I would say yes. I mean, if you're using that work, that song, that photo without the artist's permission, then there's a potential you will get a letter.
Even in my Instagram stories. That is crazy.
Even in your Instagram stories. I know.
Wow.
And I think that what Austin brought up too is a lot of artists are realizing maybe it's not so bad. People are getting our songs out there and using our music and, getting those repetitive plays and listens. Yeah. But, because I think they really try to focus on the egregious uses where people are capitalizing on it. Like selling their product with that music in the background or whatever. They're going to draw the line there. But social uses, personal uses, things like that, some turned a soft eye toward.
So I'm sure then that, so many people are using blinding lights as the music overlay on their TikToks recently. And, there's some dances that go with that. So it seems that The Weeknd should be happy that his song is being blasted and now is, top 20 on popular songs on Spotify. And he probably won't be sending cease and desist letters to all the little TikTokers out there.
You would think, but you never know.
Sometimes you never know.
Artists can be cheesy, and sometimes they say, I want to shut it down. I'm tired of it. It's kind of hard when it's out there that big. But to your point, it's that trade-off between the fame that comes with it versus the commercialization of it and the profits that are going out the door when its use is uncontrolled.
Yeah.
And in fact, the law will say if you're aware of people infringing your marks or your copyrights and you do nothing about it for a period of years, there's possible that you can have an estoppel or latches or acquiescence defenses come into play that you knew and did nothing about it, and now 10 years down the road you can't go back.
So if you are a musician and your song is being blasted over TikTok and there's a fun dance that goes with it and you don't want it happening, I guess you need to do something about it.
That's exactly right. Get a copyright registration for the song for sure. But also, too, if you see it and you don't want a person or whoever using it like that, then it's an incumbent upon you as the owner of that IP to send the letter or make it stop.
Yeah. Well, Scott, we really appreciate you being on the show today. I think probably for me, the biggest takeaway is you need to talk to an IP lawyer at the beginning stages of you developing a product, a process, a company, because it makes it a lot less expensive, I guess, than fighting it on the back end.
It's a great idea because, it's better to invest up front and get the protections in place versus having to try to get them after they're out there and those rights are starting to evaporate. So, but Austin, Andrea, thank you so much for having me on the show today. I really appreciate it.
Well, thank you so much for coming on and sharing your wisdom with us. I'm sure a lot of people are going to find this very helpful. I know I did.
Well, thank you. Thank you.
Yeah, well, and if anybody's looking to reach out to Scott, he's again at Harper, Bates, and Champion, and he's a great IP lawyer. Yeah. Like I said, I've known him for 7 years, worked with him, done a lot of great work, and he's a great person as well. So thank you again for being with us this week on #Lawyered, and we'll see you next time.
See you next time, y'all.
Thank you.